They told us, self-defense isn't a good enough reason to carry. Yeah, they actually said that. But thanks to the Supreme Court's Bruen decision, that whole lie just got torched, and the fallout's reshaping gun rights across the country faster than most people realize. What's up, everyone? This is Ted from Line 45, and today we're breaking down how a single 6-3 ruling cracked open decades of gatekeeping and why states are scrambling to rewrite the rulebook before the next wave of lawsuits hits. Before I start, I would really appreciate it if you would push those buttons below, the subscribe button, the notification bell, all of them. This is not necessary, but those little clicks help a brother out. Plus, it pushes me to give you more valuable gun-related content on your screen. Now, buckle up and let's get back to the video. If you've ever tried to get a carry permit in New York before 2022, you know the deal. It didn't matter if you passed your background checks, had a clean record, and knew your way around firearms. If you couldn't prove someone had threatened you, name, place, and sometimes even a police report, they'd stamp you denied. That's the world the Sullivan Act built over 100 years ago, and it created this gatekeeping system where self-defense somehow wasn't enough. Not unless you were a retired cop, a business owner carrying cash, or someone with political connections. Everyone else? You got filed under generalized fear, and that was their excuse to keep you unarmed in public. It got worse in places like California, Maryland, and Hawaii, or places where they'd take 6 months just to process your request, then shut it down with no real appeal. These weren't just inconvenient rules. They were legal roadblocks stacked against average, law-abiding Americans who simply didn't want to be victims. This wasn't about training or responsibility. This was about bureaucrats deciding who was worthy of defending themselves outside their home, and it became the flashpoint that eventually brought the right case to the right courtroom. Now that you know where we were, let's talk about the day it all broke wide open, and how 6 justices did what decades of lawsuits couldn't. The 23rd of June, 2022. That's the day New York State Rifle and Pistol Association versus Bruen dropped like a sledgehammer on a century of legal nonsense. The Supreme Court handed down a 6-3 of December decision that didn't just chip away at proper cause laws, it blew them to pieces. I remember reading Justice Clarence Thomas's opinion and thinking, finally someone said it, the Constitution doesn't require you to beg the government for permission to protect yourself. The heart of the ruling. If you're a law-abiding citizen, your right to carry a firearm for self-defense doesn't stop at your front door. The court made it clear. The Second Amendment protects carrying firearms in public, and the government can't force you to justify that right with some made-up need. That whole system where officials could say, sorry, we don't think you're in enough danger, dead on arrival. What stood out was the clarity. Thomas said courts must stop using interest-balancing tests, like asking if the law does more good than harm. Instead, any restriction has to be rooted in the nation's historical tradition. That meant New York's vague, discretionary system didn't stand a chance. Same goes for laws in California, New Jersey, Maryland, and Hawaii. You could practically hear the gears grinding in those state capitals. And this wasn't just a win on paper. This decision redrew the legal map for every gun owner in America. But to understand how deep the change cuts, we've got to look at the test that replaced decades of murky precedent. You see, the Supreme Court tossed out all the balancing tests lower courts had been leaning on for years and replaced them with a strict standard rooted in the Constitution's original meaning. No more weighing public safety versus your Second Amendment rights. Instead, courts now have to ask one key question. Was there a similar restriction in 1791 or 1868? If the answer's no, the law's on shaky ground. Justice Thomas made it crystal clear. It's not up to judges to second-guess how much freedom Americans should have. Their job is to apply the text of the Second Amendment and compare modern gun laws to this country's history and tradition of firearm regulation. That means if you're trying to justify a ban on carrying in subways or a restriction on magazines, you better show there was something historically similar from back in the founding era. Good luck with that. This new text and history approach has already put dozens of state and local gun laws in legal hot water. Judges in lower courts have openly admitted they're struggling. Some have said they're basically historians now, forced to comb through 18th century laws to decide 21st century cases. But that's the point. The court stripped away the wiggle room that anti-gun states used to exploit. And if you think that only applies to carry permits, think again. Because what started with Bruen is quickly becoming a wrecking ball aimed at the broader world of gun control. Once the ink dried on the Bruen decision, states like New York, California, and Maryland didn't fold. They retaliated. Almost overnight, they rushed out new laws designed to give them just enough plausible cover while still trying to control who carries and where. They called it compliance, but let's be real. It was defiance in a cheap suit. These legislatures slapped together bans on carrying in so-called sensitive places, jacked up training requirements, hiked permit fees, and started flooding permit applicants with paperwork. New York led the charge with the Concealed Carry Improvement Act. It turned huge chunks of public space into gun-free zones. Times Square, public transit, parks, churches, even some private businesses, unless there's a guns welcome sign posted. You could have a valid permit and still be walking a legal tightrope through your own city. California followed suit, pushing forward SB 2, which added over 20 categories of restricted areas, while also tweaking permit qualifications. And states like New Jersey and Hawaii adopted similar tactics. All of this was designed to stall momentum and maintain the gatekeeper role without triggering another direct conflict with the court. But they're playing with fire. Lawsuits came in hot. Federal courts in New York and New Jersey have already ruled that parts of these sensitive location laws go too far. Injunctions were issued. Appeals are ongoing. What we're witnessing is a tug-of-war between constitutional carry rights and state-level resistance. But that legal chaos isn't happening in a vacuum. It's now bleeding into public safety debates, with both sides citing stats. There's been a lot of shouting in both directions. Some say Bruen is going to unleash chaos. Others say it's a return to sanity. I don't panic or pipe dreams. I look at the numbers. And when you dig into what researchers have actually found about shall-issue carry laws, you'll see it's a bit more complicated than the headlines make it out to be. Let's talk about hard data. A massive Rand Corporation review of over 100 studies found some credible evidence that shall-issue laws correlate with modest increases in violent crime over time, especially in urban areas. Some studies, like one from Stanford University, showed a 13 to 15% rise in violent crime over a decade in states that loosened their permitting standards. Others argue the effect is overblown or influenced by variables like poverty, police funding, and gang activity. But here's the kicker. None of these studies say law-abiding gun carriers are the ones driving up crime. The issue is how relaxed laws might make it harder to separate good actors from bad ones. On the flip side, states with streamlined permit systems, like Utah and Indiana, report strong compliance, low misuse rates, and very few revocations. In Florida, the Department of Agriculture's concealed carry data shows a permit revocation rate of less than 0.1% annually. So what does it all mean? The court ruling didn't spark a bloodbath, but it didn't end the debate either. And now, we're seeing real-world pressure on cities and counties that are trying to control the outcome without breaking the law. While the Bruen decision was loud and public, the resistance that followed was quiet and tactical. You won't always see it in headlines, but go try applying for a carry permit in certain counties and cities, even in shall-issue states, and you'll find the fight hasn't ended. It just moved behind the counter. Take Honolulu, for example. After years of denying nearly every single carry permit, the city found itself in court when delays stretched months with no clear explanation. That lawsuit forced the department into an agreement. Decide on applications within 120 days, and implement a streamlined online system by 2026. Sounds like progress, but it's also a signal that some places are dragging their feet until they're forced to move. Then there's New Jersey, where, after Bruen, some townships quietly tried to require multiple notarized character references on top of what the law demands. In Maryland, state police initially delayed approvals while scrambling to write new emergency guidance. In California, counties like Los Angeles and San Diego saw massive permit backlogs stretch beyond 6 months. It's not that these places are flat out refusing permits. They're slow, walking the process, making it painful, bureaucratic, and discouraging. It's a tactic built on attrition. The longer they can stall, the fewer people apply. But the numbers are still growing. In Washington state, for example, active concealed pistol licenses broke 709,000 in July 2025, the highest in state history. This push-pull between demand and delay sets the stage for something bigger. Because if you think carry laws are the endgame here, you're not looking at the bigger map. If Bruen cracked the dam, what's rushing through now is a flood of lawsuits challenging every corner of modern gun control. We're not just talking about carry permits anymore. This decision kicked off a constitutional arms race, and the next wave is already hitting assault weapon bans, magazine capacity limits, ammo restrictions, and even transport laws. And the courts? They're starting to listen. Take California's ban on large-capacity magazines. A federal judge struck it down, again, in 2023, citing Bruen directly and noting there's no historical equivalent from the 18th or 19th century to justify the restriction. Illinois' assault weapons ban, also under fire, with lawsuits from groups like the Firearms Policy Coalition and the Second Amendment Foundation zeroing in on Bruen's demand for historical analogs. If the founding generation didn't ban muskets or powder reserves, how do you justify banning AR-15 second and standard 30-round mags now? Even non-lethal carry laws are facing heat. New Jersey's rules on transporting guns in locked containers from one residence to another? Challenged. Hawaii's mandatory registration policies? On the chopping block. Lower courts across the country are split, with some upholding laws and others knocking them down, almost guaranteeing that SCOTUS will have to step in again soon. This fight's far from over, even now in 2025. The legal landscape is still shifting, and if you're a gun owner or just someone who believes in personal liberty, you need to pay attention. What Bruen started is reshaping the Second Amendment in real time, and trust me, the biggest battles are still on the horizon.